Hello. Part 6. Motion of reconsideration of Judge Allen's October 27th, 2009 order. D. New matter counterclaim, contractual interference. To prevail on a cause of action for tortious interference with an existing or prospective contractual relation, a plaintiff must prove the following elements. 1. The existence of a contractual or prospective contractual relation between the complainant and a third party. 2. Purposeful action on the part of the defendant specifically intended to harm the existing relation or to prevent a prospective relation from occurring. 3. The absence of privilege or justification on the part of the defendant. And 4. The occasioning of actual damage as a result of the defendant's conduct. Strickland versus the University of Scranton, 700, Atlantic 2nd edition, 979. Pinpoint, 985. PA Super, 1997. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff/defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009. E. New matter counterclaim conspiracy. The Pennsylvania Supreme Court set forth the elements of civil conspiracy in Thompson Coal Company versus Pike Coal Company, 488 PA 198, pinpoint at 211. Second citation, 412 Atlantic 2nd edition, 466, pinpoint at 472, 1979. It must be shown that two or more persons combined or agreed with the intent to do an unlawful act or to do an otherwise lawful act by unlawful means. Proof of malice, i.e., an intent to injure, is an essential part of a conspiracy cause of action. This unlawful intent must also be without justification. Furthermore, a conspiracy is not actionable until some overt act is done in pursuance of the common purpose or design, and actual legal damage results. Defendant/plaintiff Patricia Gray sufficiently pled or established the elements necessary for this count in the amended joinder complaint and new matter counterclaim. Plaintiff-defendant Perry did not address these elements in any of her pleadings or at the rule returnable hearing October 27, 2009. F. New matter counterclaim, imposition of constructive trust. The defendants, by collecting the rent from the property co-owned by Mrs. Gray and not escrowing the rents and never giving Mrs. Gray her share, were unjustly enriched by retaining her share of the rents and living in an apartment without compensating her, thus establishing a constructive trust. A constructive trust may be imposed where a person holding title to property is subject to an equitable duty to convey it to another on the grounds that he would be unjustly enriched if he were permitted to retain it. Core versus Core, 271 PA Super, 321, pinpoint at 329, Second citation, 413, Atlantic 2nd edition at 691. In deciding to impose a constructive trust, the central focus is on avoiding unjust enrichment. Kaufman versus Smith, 453, PA Super, 15. Second citation, 682, Atlantic 2nd edition, 1282. The facts in this case conform to the definition of a constructive trust as set forth in Kern versus Kern, 892, Atlantic 2nd edition, 1. Appeal denied, 2006, PA Lexus, 1384, Pennsylvania, August 1, 2006. A constructive trust is defined as a relationship with respect to property subjecting the person by whom the title to the property is held to an equitable duty to convey it to another on the ground that his acquisition or retention of the property is wrongful and that he would be unjustly enriched if he were permitted to retain the property. The imposition of a constructive trust is appropriate only where the defendant has no right whatsoever to the property he holds in violation of the plaintiff's right. Hino Motors, Inc., 16, Atlantic 2nd edition, at 765, pinpoint at 766. In the instant matter, the defendants have no right to keep Mrs. Gray's share of the rent and occupy the apartment. A constructive trust is the formula through which the consciousness of equity finds expression. When property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts to a trustee. Chambers versus Chambers, 406, PA 50, second citation, 176, Atlantic 2nd edition, 673, 1962. In Beatty versus Guggenheim Exploration Company, 225 NY 380, pinpoint at 386, second citation 122, Northeast 378. Continuing, the Chambers Court, quoting Beatty, observed, the equity of the transaction must shape the measure of relief, quoting Beatty Supra. Our Supreme Court has stated the requirements for a constructive trust in Belizik versus IRENE, 518 PA 127. Second citation 541, Atlantic 2nd edition, 1130. A constructive trust arises when a person who holds title to property is subject to an equitable duty to convey it to another on the ground that he would be unjustly enriched if he were permitted to retain it. One necessary aspect of the defendant's holding title to property is that he must have acquired it in some way that creates equitable duty in favor of the plaintiff. A constructive trust is the formula through which the consciousness of equity finds expression. When property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee.